first, and we'll get to as many questions as we can at the end of the presentation. Trying to click to the next slide here. There we go. We welcome participants from across Alaska today who are joining at the invitation of one of the 11 affiliate community foundations. Affiliate community foundations empower and grow localized philanthropy, really creating charitable resources for their towns and regions. As some of you know, the Alaska Community Foundation's mission is to connect people and organizations with causes that will strengthen Alaska now and forever. Some of the connecting that we do takes the form of current donations to existing funds at ACF, and that includes donations to the endowed funds of our 11 affiliates, and of course, granting out from all of the funds at ACF to nonprofits to meet current needs throughout our state. With the support of the Rasmussen Foundation, ACF provides matching funds to affiliates, incenting their donors to contribute to their endowed funds. ACF also works with people like you who are planning for the future, and we can help you put in place legacy plans that will ensure your vision for Alaska. There are many ways to give to organizations, communities, and causes that you care about. And if you're thinking about current giving options, of course, you can give cash or other current assets. Appreciated stock or mutual funds are a great option because you can avoid capital gains tax while making a substantial gift to your favorite charity. And if you are 72 years or older, you have the option of directing your required minimum distribution from your individual retirement account to charity. If you don't need the full amount of your RMD for your living expenses, you can gift that to charity and not pay taxes on it. Another option is to set up a donor advised fund at ACF to provide you flexibility in your charitable giving and tax savings. We'll talk more about this option a little bit later in the presentation. As you look to the future, you can name a charity as a beneficiary of your retirement account. And of course, you can leave a gift to charity in your will or estate plan. And of course, that brings us to why many of you have joined us today. You have some interest in learning about creating a will or estate plan. And with that in mind, I want to pose just a few questions for you to consider as you work through your wills and your estate plans. And the first set of questions is really about the people in your life. And most of you probably have already thought about this, but who do you love? Who do you care for? Who do you find comfort from? And for most of us, we're thinking about family. Who gives you practical support? That too might be family. It might be a caregiver. It might be a nonprofit. And these are all people or organizations that you might be thinking about including some way in sharing the proceeds of your estate. The second set of questions is more about the causes that are important to you. What gets you out of bed every morning? Or what issues keep you awake at night? And as you think about those might be causes or nonprofits doing work related to those causes that you might be considering naming in your will or estate plan as well. And then the third set of questions is more about logistics. You might be thinking, well, I like all of these organizations, or I have all these causes. I wonder where the biggest need is, or where it's going to be. And where do you find information about that? And certainly the Community Foundation and the University of Alaska Foundation can help you answer some of those questions. The Alaska Community Foundation can certainly help you if you are interested in leaving a legacy here in Alaska. And the first part of this, though, I say is if you aren't interested in leaving a gift to charity, you really don't need ACF. Or if you have a few specific charities that you want to name in your will, you can do that and have the full amount go to those nonprofits directly from your will, your estate when it's settled. However, if you want to leave some money to charities and have funds be granted out to those organizations over time, that's something ACF could help you with. Or if you're concerned that by the time that you pass on, the charities you listed might not be around, but you'd like to ensure your money goes to organizations with similar missions, that's something else that ACF can help you with. If you have a cause or a general area of interest that you want to give gifts to from your estate plan or your will, we can help you do that. If it's not a specific charity, but a cause. And if you have a vision to create something like a family foundation with the proceeds from your estate, we have a very simple way that you can do that. And the basics of establishing legacy plans at ACF are really very simple. You work with me to set up the framework of your fund. We document your wishes. And then at the same time, or somewhat in concert, you work with your estate planning attorney to name that special fund that you've set up here at ACF in your will. And then that fund here at ACF remains dormant until it is activated by the proceeds from your will. The fund agreement that you set up here is revocable, so you can change it at any time prior to your death without changing your will. And with those introductory comments, I now would like to introduce Harry Need. Harry is the Senior Director of Philanthropic Services at the University Alaska Foundation, and Harry's going to provide a few words of welcome from the UA Foundation.
Hi there. My name is Harry Need, and through the UA Foundation, it's my pleasure to get to work with donors to the University of Alaska system. As many of you online here are associated with UAA and our other universities in Alaska, you'll know that I have also several colleagues across the system who work with alumni and donors like you who want to invest in our pursuit of creativity and research and education, some of whom are actually taking this very seminar with you. Particularly, I get to work with those of you who are making complex or non-cash gifts or pledges to any area of passion at the University of Alaska. Most commonly, these take the form of simple plan gifts that are written into wills, as Elizabeth discussed. And we'll discuss some other strategies later in our presentation. All those gifts are received and managed by the UA Foundation, all those gifts to the University of Alaska, that is. And we distribute that support across our system through thousands of funds and hundreds of endowments in accordance with each of our donors' intentions. So thanks to our donors, the UA Foundation is able to distribute about $14 million per year to the University of Alaska. About 4.3 of that is in the form of direct student support. Thanks to the Alaska Community Foundation for hosting this wonderful event, and to its donors whose cumulative giving to the UA Foundation is approaching $2 million right now. Pretty exciting. Thanks to Chelsea and her firm Foley and Pearson, whose professional services to our donors have benefited our community several times over and in ways we probably don't even know about yet. And thanks to each of you attending for your loyal support and investments in our community through the Alaska Community Foundation and the University of Alaska Foundation. I look forward to serving each and every one of you as you consider your charitable estate plans, and please don't ever hesitate to reach out to Elizabeth or I for any support. So cheers.
Thanks so much, Harry. And before I introduce Chelsea, I do want to call out a very special person who is attending today. We have with us as an attendee, Susan Foley. And Susan has a very special part with each of our organizations. Of course, she is an estate planning attorney and was part of Foley, which is now Foley and Pearson. And she was the interim CEO and president of the Alaska Community Foundation not too long ago. And then, of course, served as the CEO and president of the University of Alaska Foundation. So, Susan, we just wanted to say thanks for joining us today, and it's a delight to have you on this webinar with us with three organizations that you've done so much for. And with that, I will advance to my last slide and introduce Chelsea. And it's such a lovely picture of you, Chelsea. I don't know where it is.
Thanks. So many headshots to choose from.
Yeah. Well, I am delighted to get to introduce Chelsea Ray Ricola. She's an attorney and a shareholder at Foley and Pearson. She was born and raised in Anchorage and attended Missouri State University, and I was fascinated to learn this. She attended on an athletic scholarship for swimming and diving. After graduating with a bachelor's degree in marketing, she received her law degree from the University of Oregon. And her focus there was on estate planning and probate law. And while at law school, Chelsea wrote and published an article for the American Bar Association Journal of Real Property, Trust and Estate Law. Sounds like great bedside reading. And that article was on the handling of digital assets after death. I think that was really fascinating. Since 2013, Chelsea has been back in Alaska, and she has a passion for outdoors that is not limited to the season. She enjoys trail running, gardening, hiking, and skiing. Chelsea has generously volunteered her time for today's presentation. And with that, please help me, Chelsea Ray Ricola. Chelsea, I will stop sharing my screen so that you can share yours.
Perfect. All right, that should be good to go. Can you see my screen okay?
Yes.
Perfect. Okay. And yes, hello to Susan, the founding Foley of what was Foley and Foley and later became Foley and Pearson, and then now is Foley and Pearson. She was a great mentor for me, so I'm pleased that she's on this call. Hopefully I knocked this out of the park since she's the OG workshop presenter. Well, just a little bit about our firm. You know, Susan was the founder. She was joined later by her husband, Richard Foley. We focus very strongly in the area of estate planning. We don't do really anything other than estate planning and administration of those estates, business planning as it relates to estate planning. So we like our little niche. And that's why I'm here to talk to you today, because it sounds like you're interested in hearing more about estate planning and the problems that it might be able to solve. If you have questions related to estate planning, I do encourage you to go ahead and type them into the chat box not the chat box, the Q&A box as we go, because chances are if it's on your mind, somebody else on the call is also having the same question. So feel free to add those anytime and upvote the ones that look helpful. So we're going to cover some stuff today about estate planning in general, you know, what it is, how it works, the problem of title, and why that might be a problem. I'll also talk about the probate process, you know, what happens when somebody dies and if they have a will, if they don't have a will, kind of how that unfolds. Also, powers of attorney, healthcare directives, a little bit of incapacity planning. Then we'll touch on the basics of wills as well as beneficiary forms, other ways to designate beneficiaries on accounts, jointly titling things. And then we'll take a stretch break and a deep breath and talk a little bit about trusts and how they're different from wills. I promise to keep it at least mildly entertaining. That I can promise. And then we'll talk in the context of trusts about protecting inheritance for loved ones, estate tax basics, because can't leave this workshop without talking about estate tax, and of course, charitable legacy planning, some other odds and ends. But we do want you guys, because it seems like you may be interested in charitably planning, to know about kind of what some of those options are. And Harry is uniquely qualified to talk about some of that, as is Elizabeth. So they'll be chiming in there at the end. Okay, so what's estate planning? Well, it's broader than you might think. So it's not just for fancy people. People, I think, imagine kind of this Downton Abbey idea when they think of the word estate, right? Manicured lawns and servants, which is not the case. Your estate is just what you own. It's what you have that's yours, your property. And so anything that you do that affects how that property is transferred, or who can manage it, or who receives it at your death or your incapacity, is actually an estate planning decision. So chances are you've already done some estate planning, whether or not you recognized at the time that that's what it was. Examples would be a joint titling of a bank account, husband and wife bank account, or maybe a parent-child joint bank account. That's an estate planning decision, because if one person dies, the other one's now the sole account holder. Similar pay on death designations, transfer on death designations, doing a beneficiary on that IRA paperwork when you start your job, that's all estate planning. And so this is really part of a bigger picture that is estate planning. Estate planning is the forest, and those different decisions are the trees, right? So why do we engage in estate planning? We're concerned about cost, right? And sometimes we're concerned about family drama. We're trying to avoid the kind of messy, horrible things you hear about getting dragged through the court system. So to the extent that is possible, we put neat and tidy estate plans in place. That doesn't always prevent all the issues, but it certainly does a better job than not having any plan at all. So let's talk a little bit about title. Basically, the title of property is just how it's owned, right? And that can really affect how your property passes at your death, or when you become incapacitated. So the legal process actually differs depending on what kind of property it is. Is it a bank account? Is it real estate? Is it an investment account or life insurance? And then how it's titled, right? Is it joint? Is it joint between spouses, or joint between siblings? Is it just you? Is it in the name of your trust? We'll talk about that later. So we have a handy dandy little chart to just lay out kind of some of the common forms of property we see in a typical portfolio. Maybe you've got one or more of these in your own portfolio, and how they pass at death or incapacity. So for bank accounts and real estate, when you die, if that property is just in your name, you, the person who just passed away, that means that it has to go through probate, typically. If you're incapacitated, somebody with a power of attorney can manage that property for you. Now, joint property is where it gets a little hairy, because joint property can apply to bank accounts or real estate or other types of assets. And that's what I just referenced, right? It can pass automatically at the death of another. So it's an operation of law transfer, right? There's no probate necessary when somebody on a joint bank account dies, because the other account holder is now the sole owner. For incapacity, just because one of the account holders loses capacity doesn't mean the other can't just move the funds, right? Now, life insurance and IRAs function in a similar way in that they both have beneficiary designations, and those should always be filled out. I can't tell you the number of times we've seen beneficiary forms that never were completed, and so assets are going to an estate that shouldn't, or we see horribly outdated beneficiary designations. Somebody got divorced, never took their ex off of the form, or they listed their one child, then they had two more. That's kind of how it goes. So I will encourage you guys later, but I'll say it right now. Just check your beneficiary forms. We don't do it often enough. It's like going to the dentist, right? It's maintenance. You should just do it every now and again. Okay, so I'm going kind of quickly here. I'm sure you'll notice we have a limited amount of time. If there are topics here that you're interested in that I didn't cover, be sure when we send out the evaluation link to kind of reference those in the boxes you can fill in. It will give you an opportunity, if you want someone from our firm to call and try to answer those questions. We usually do. There's a lot of people on this call, so it's going to take us a while to get through all the people that typically have questions. It does wind up being a lot. And I am actually jumping on a plane after this, so it's going to be about a week before I start making those calls. So, okay, probate. It gets such a bad rap, but as Bill Pearson likes to say, it's not a good process. It's not a bad process. It's just a process. So there are things that people don't love about probate. And if you don't love the idea of probate after hearing everything about it, the option for you might be a trust. But for anybody with just a will or no estate planning in place, when they die, typically probate is how those assets are passed. What it is just a court process that takes somebody, later called the personal representative. They get the authority to manage the assets, consolidate accounts, file tax returns, sell things, and eventually provide an accounting to the heirs of the estate or the beneficiaries. And then they distribute the money at the end of that, which sounds really simple, right? How hard could it be? If you know anybody who's been a personal representative for an estate, then you know that it's not probably as simple as it first appears. There's a lot of work, just in trying to get a hold of all the asset information or get the tax returns filed, or provide all the required notices to beneficiaries and to creditors, because creditors are entitled to notice. There's a 4-month creditors claims period. That notice has to be published. So there's lots of little nitty-gritty pieces, boxes that have to be ticked. But essentially, the idea is it's the process by which somebody gets the property from the deceased person to their heirs or beneficiaries. And typically in an informal probate, which is what I do 98% of the time, the court is just rubber stamping things, right? Like everybody's getting along, it's copacetic, even if people are, they're not talking to each other as family members, they accept that the paperwork is what it is and nobody's suing anyone over anything. Personal representatives have a fiduciary duty to the creditors and to the heirs of the estate. They have to put the interest of those people ahead of their own, which can be tricky. I get this question a lot, like, is the personal representative allowed to be a member of the family? Yes. In fact, that's typically the case. It's oldest child or, my brother Joe named as personal representative, and they are also receiving something from the estate under the will or by intestate succession. Happens all the time. But that person does need to be very careful to put the interest of the beneficiaries as a whole ahead of their own personal best interest, right? They can't just buy the house from the estate and cut themselves a deal and buy it for tax assessed value if not every other, heir is on board with that. So choosing a personal representative is one of the most important things you can do in your estate planning, because it ensures that the right person for the job will be the one tying up all of those loose ends. A lot of pain and heartbreak can come from not choosing a personal representative and leaving it to the 5 kids to decide amongst themselves who should do that job. So I'm just going to look and see. Okay, so for our purposes today, I'm going to touch also on incapacity planning before we jump back into wills. So that was a little bit about probate. Now let's talk about what happens before probate. A power of attorney document is strictly for financial decisions. So this is separate from a healthcare directive. I'll talk about that next. But a durable power of attorney, springing power of attorney, and limited power of attorney are the 3 flavors of power of attorney that you can create. So durable powers of attorney are documents that are in effect right now. So the date that you sign it, poof, it's effective. And they stay effective even if you lose capacity. So we do a lot of these for husbands and wives, or husbands to husbands, wives to wives, spouses and spouses, who are doing their planning in a way that they're already joint financially, or they trust the other implicitly with their financial affairs, right? They want that person to be able to pay bills instantly if anything happens to them. Now, the alternative is a springing power of attorney, where you say, well, I don't want you to have this authority right now, but if I lose capacity, then I want that authority to be effective. Now, what that means is it's more protective, but that also means red tape. So functionally, if somebody has a springing power of attorney rather than a durable one, that means that the agent, the person who is doing the job for the person who's incapacitated, they now have to take 2 written affidavits from two separate physicians with them to every institution, to every bank, to show the bank that two separate doctors have concluded that this person has lost capacity and can't manage their own financial affairs. And so then with those two affidavits in hand, your agent trots around to all the banks and gives them those affidavits. The affidavits then get sent to the legal department, then they go back to the banker, in the 3 to 5 business day window. So, it's just a lot more of a headache for your agent. But because of that, two separate objective third parties are going to confirm that that power of attorney should be effective, and nobody can use that authority until you get that documentation. Now, this third one, a limited power of attorney, is used for just a finite task. In our practice, where we see this come up is sometimes with real estate closings, where you'll have a client that's down in the lower 48. They don't want to have to fly up and deal with all the closing nonsense for the house. So they'll delegate that authority via a limited power of attorney to one of us in the office, the attorney on the case. And then the only thing I can do with that power of attorney, it says right on the document, is, execute closing documents on the transaction for blah, 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 comma, Anchorage, Alaska, 995, whatever. If that transaction is the only transaction authorized on the power of attorney, I can't use that limited power of attorney the same way I'd be able to use a general power of attorney, where I just walk into a bank and I can clean out an account, right? It's just for that one task. Keep in mind that these don't stay effective once the person, the principal who did the power of attorney, once they die, no more power of attorney. I know that's actually a common misconception, is everyone, says, oh, it's okay, they didn't have a will, they had a power of attorney. No, power of attorney is not helpful once you die. It is no longer useful. But while you're alive, very helpful, right, to have somebody to be able to manage your financial affairs. Considerable power with limited oversight. Choose wisely, right? You want to be able to trust this person implicitly. If you cannot trust them, they should not be your agent, and you should look for other options, maybe even a professional fiduciary like a bank or a trust company or a professional guardian. Okay, so healthcare directives. All right, lots more fun things to talk about with incapacity. It's important to have. And I will say this document is not necessarily for you so much as it's for your loved ones, right? You want them to feel like they are making the right decision if should they find themselves in the doctor's office, having medical terms hurled at them, trying to make a decision, and it's the end of your life and they just want to make the right call. If you have a document that gives them some guidance, they at least have that to hang their hat on. Without that document, they're kind of flying blind, right? They're like, I don't know, what would mom want? Did we ever talk about it? I don't remember. So your healthcare directive does two very important things. It designates your agents, so who's going to make healthcare decisions for you, and it allows you to actually give instructions about end-of-life care. Do you want your life prolonged? Do you want all the heroic measures? Do you want, a feeding tube and IV for an extended period of time? Or do you want them to stop all of those measures depending on the circumstances? You can check different boxes and communicate that on the form. Now, your healthcare agents and your power of attorney agents don't have to be the same people. Maybe one of your kids is a CPA and the other one's a registered nurse. Great, you have something for everyone, right? But in a lot of situations, it does wind up being the same people, because the most responsible kid in the bunch is just the most responsible kid, and that's the way it is. So the good news is you get to decide, as long as you actually do your healthcare directive and power of attorney. I will say, this is my plug for the state of Alaska, you do not have to see a lawyer to do these forms. Those are available on the state of Alaska website. The court system has a power of attorney, and DHHS, I think, has the healthcare directive form available. So if you're like, lawyers are too expensive, I would argue it's worth it. I'm a lawyer, right? Take it with a grain of salt. But if you want to have those documents in place, and I recommend everybody does, then you can get them off the internet. They're free. If you find a website that's trying to charge you for them, it's not the right website. Okay, so what happens if you don't have a power of attorney and healthcare directive? Well, then you might wind up in guardianship or conservatorship land, basically the court supervised care of an incapacitated person or just their finances. Conservatorships are just for finances. Guardianships are for the whole person, sometimes also with a financial component. Oh, the court tries so hard, but they are so backlogged. It is a long, long time before you get hearings in guardianship cases. Sometimes COVID didn't help with that. They're understaffed and overworked. It's just the way it is. So there are a lot of time delays that come with that, not to mention the emotional cost of having to testify, especially sometimes if the person who needs the guardianship, maybe it's an aging parent, doesn't think they need a guardianship, but it's clear to every other member of the family that they do. That can be really heart-wrenching testimony, right? To have to stand up there and say, you know what, mom should not be in charge of her own checkbook. She just wrote a $250,000 check to a scammer. Like, somebody should help her. So, to the extent that you can put these measures in place to prevent a guardianship or conservatorship, it prevents a lot of added expense and emotional cost. Okay, now we're going back to death. It's a small foray into incapacity. We're back to when you die. Okay, basics of wills. What is intestacy? Well, it's dying without a will. Testate, last will and testament. Intestate, no will, right? So don't worry if you don't have a will, the state of Alaska has done one for you. Now that does not avoid probate, and there's no tax planning, and there's no planning for incapacity or for minor heirs. And by doing a will, I mean, it's just the Alaska statutes, and they say that something happens to your stuff. But there's a plan in place. Sometimes people are scared that their estate will escheat back to the state. No, this is not the case. Trust me. Someone you're related to will benefit from your property. I have multiple estates right now where it's like tangential cousins or nieces and nephews of a decedent who didn't have a will, and they had like zero relationship with those people. But it is what it is. So, if you're that person, no spouse, no kids, and you want to do something good with your money and leave it to a charity, it's on you to make that call. Got to do it while you're alive and well. So let's say you do have a will. What does it do? Well, it only transfers the property that's just in your name, right? And just to be clear, again, joint bank account. If you have a joint bank account with someone and you do a will and you say, when I die, I leave my property to so-and-so. When you die, this bank account is joint with someone else. It's not part of that equation. So this bank account passes to the other joint owner. But your other property that's just in your name, perhaps your real estate, your car, your investment account, that passes according to the terms of your will. And you can do it in two different ways. So if you have a will, or a trust for that matter, you can leave property either by a specific distribution. I leave my Smith & Wesson, blah, 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 shotgun serial number, blah, 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 to my cousin Benny. Or you can do a residue bequest. I leave cousin Benny 5% of my total estate. So there are different ways you can provide for different people. My least favorite thing is when every single, I sometimes see this in old wills, every single asset that a person owns is listed in a specific distribution. And it's like, I leave my house to this person, and I leave this bank account to this person, and this bank account to this person, and this bank account to this person. And then 30 years has passed, they moved houses, they closed this account, they moved this account to another one. And this one still exists, but they added their kid to it, and then they died. Problem, right? So I don't love too many specific bequests for that reason, but you can have that conversation with your estate planning attorney. I recommend it. Oh, and another important thing, you get to name your personal representative, right? I just said that's one of the most important things you can do. You do that in your will. You can also name guardians for minor children, or if you have an adult child with special needs and you're their legal appointed guardian, you can actually name a successor guardian for them as well. And you can create a testamentary trust for loved ones, which we will talk about in a few minutes, kind of the second half of things. But your will not get you out of probate land. Again, it's just a process. It takes a year-ish, maybe two, if the real estate takes too long to sell. If it takes 3 years, something's gone a little bit sideways. If it takes 5 years, it's probably because there's litigation. But the court is involved, so there's potential for time delay. Fun fact, it's a public process. So if I die and my estate's being probated, Joe Schmo off the street can walk into the probate court and say, Madam Clerk, I'd like to see the probate file for Chelsea Ricola. And Madam Clerk will say, just 1 second. Here you go. You can make copies, but you can't take it with you. right? And so all of the information for the estate is in there, names and addresses of beneficiaries, a copy of the will, sometimes the values of all the assets of the estate, like it's all just public record. So if you don't love that, maybe again, that's a point in the trust column versus the will column. And of course, for all you snowbirds out there, potential for probate in multiple states. So if you own dirt in any one state, that state's going to be concerned about that chain of title. So they're going to try to make sure that that passes through their probate process in order to make sure that the chain of title stays intact. So if you have an Alaska residence and a Washington condo, you have a probate in Alaska and a probate in Washington. A trust is a solution to that. This is my theme. We'll talk about that a little bit later. But again, this can be really problematic once you have multiple pieces of real estate in multiple states. The more states you're touching, like the worse the problem, right? If you also then have your condo in Hawaii, now there's a Hawaii probate and a Washington probate and an Alaska probate, which means you have a Hawaii lawyer, a Washington lawyer, and an Alaska lawyer. Nobody wants 3 lawyers. Like that's terrible. There's a problem if you have 3 lawyers, right? So, and right, I did talk about joint titling and how the will doesn't control those assets if they're jointly titled or if they have beneficiaries on them. So let's focus on that for just a second. Let's say mom's will says, I leave everything to my 4 children equally, but mom listed just her oldest child on her IRA as the sole beneficiary. What happens? Well, the child listed on the beneficiary form gets the IRA. It doesn't matter that she did a will saying all 4 of my kids. So this can be really problematic for tax reasons, right? Because IRAs are income taxable. Even if the child wanted to do the right thing, right, and take it and split it amongst the other siblings, there are all sorts of tax problems with that. So it's really important to kind of understand that beneficiary forms and your will are 2 separate parts of your estate planning. We're going to look at everything as one big picture. Now on those forms, you can name people, you can name your estate, or you can name trusts. There may or may not be tax or other reasons why you'd want to do that. So you want to be really careful and have that conversation with an attorney when you're messing around with beneficiary forms and thinking about naming your estate. Just be careful with that one. And joint tenancy, I know I talked about this earlier, you know, one person dies, it's the other one's account. Yeah. Okay, so here's the other thing that I think gets skipped over a lot of the time. If you have 2 account owners, like let's say mom and child is going through a divorce, and now child's assets are subject to the terms of the divorce decree. Is this asset subject to the terms of the divorce decree? Maybe. Or if child gets into a car accident and now they have a $2 million judgment hanging over their head, is this asset attachable? Maybe. So perhaps by adding somebody as an owner to the account, you've created an unintended liability connected to the person you added. My suggestion, the lawyerly suggestion, would be don't put the person on your account, do a power of attorney and designate them as your agent. Then you've created the authority to access the account and assist with management of that account without creating ownership rights. They can help you pay your bills, but they don't own the money, right? That's what a power of attorney does. Okay, trusts. What is a trust? Oh, we have a couple of handy dandy analogies, but we also have this lovely legalese that you see on your screen. I won't even read that definition to you because I don't think it's all that helpful, although it is technically correct. But let's think of a trust as first a corporation, right? And the example we love to use is Ray Kroc, right? Founder of McDonald's, or the guy who stole the idea from the McDonald's brothers, depending on who you ask. So Ray Kroc, no longer with us, right? But McDonald's, definitely still with us. So what is it that Ray Kroc is that McDonald's was not? Ray Kroc was a human. He was a mere mortal, like the rest of us on this call. So the corporate entity kept surviving, doesn't die, it just keeps on going and going and going in perpetuity. A trust can be kind of like that. A trust does not die. And also, like a corporation, a trust has a person who created it, right? Ray Kroc was the founder of McDonald's. Your trust requires a trust maker. Sometimes you'll hear them called a settlor or a grantor. If you hear those terms thrown around, we use trust maker because it's the person who made the trust. Duh. And then you have the CEO of the corporation. That's the person making the day-to-day management decisions. In the trust context, that's the trustee. The trustee is the CEO of the trust, taking money out, putting money in, buying things in the name of the trust. That's the trustee. And then finally, you have the beneficiary. So in the corporate context, the shareholder, during his life, Ray Kroc was the sole shareholder of the corporation, and he made all the money. During your lifetime, when you're the boss of your trust and you're the CEO and you're also the beneficiary, you reap the benefits, right? It's your money. You get the income from your investments. So that's how a trust is similar to a corporation in structure. The other analogy we like to use is the bucket, which you'll see a pretty picture of a bucket, but that's not the only bucket, because I do bring my bucket to the Zoom. But this is not a bucket. This is the Chelsea Ray Ricola Living Trust. And in order for it to work, I must actually put my assets into the bucket. So this bucket has the name of the trust, but it also has my social security number. As far as the IRS is concerned, this does not exist, right? The IRS is like, no, there's Chelsea. Chelsea files her 1040 on time every year, usually with an extension. But this bucket is completely disregarded. So what happens is we retitle assets in the name of the Chelsea Ray Ricola Living Trust, which has my social security number. So I move my, Apple stock, I wish, into the name of the trust. I deed my house to the trust. So I'm the owner of my house. I hereby transfer my house to the Chelsea Ray Ricola Living Trust. I perhaps even transfer my business interest into the Chelsea Ray Ricola Living Trust. I retitle my bank accounts into the Chelsea Ray Ricola Living Trust. And now, when I die, I don't own property, my trust owns property, which is great because when I die owning property, I create a probate, but I didn't own anything and my trust can't die. Slick, right? So when I kick the bucket, my bucket just gets handed over to a successor trustee. Somebody else becomes the trustee and can manage this property, take assets out, put them in, and that same management authority can actually be transferred, not just if I die, but at incapacity. So if I lose capacity, there's a trigger in the trust document. In case you're wondering what a real trust looks like, I don't send you home from our office with a bucket. I send you with a book. We call it the red book, right? Or the red binder, the estate planning portfolio. And this has the terms that say how it's determined when somebody is incapacitated. Is it 2 licensed doctors? Is it an incapacity panel? So whatever the trust says, once that criteria is met, I'm declared incapacitated. My new successor trustee takes over and can pay my bills using the money in the trust, can sell everything if they need to, especially if I go into assisted living, I'm not using my house, may as well liquidate it. And that's their responsibility. Now, once I die, this document does function as that bottom line right there, a will substitute. So it says what happens to my stuff at my death. And it might be that this money goes into sub-trusts, little tiny buckets for my beneficiaries, or big buckets, depending on how well you've saved. Or maybe it just goes outright. My beneficiaries just get checks and they can do with them whatever they want. We'll talk a little bit more about that in the coming slides. But essentially, that's the idea of trusts, right? It's this bucket. You can hand it the authority to manage it over between parties. And for those of you who might not have somebody that you want to designate, like if you don't have a human person in your family or friend circle that you would be comfortable designating as the trustee, this is where a corporate trustee can come in. A bank or another institution could serve as a professional trustee, which of course they charge for their time. Spoiler, so do your family members, because it's actually a statutory right to charge for one's time in administering a trust, which makes sense because it's a job, a big job. It's a lot of work. Okay, so I covered most of this. Retitling assets is one of the critical parts. I did kind of say, well, I just put stuff in the name of the trust. sometimes assets are not ideal to hold in the trust during your lifetime. Maybe there's business interests and you don't want to mess with the corporate paperwork, or there's restrictions on transfer. You can do things like pay on death designations and then designate the trust as the beneficiary, which is one way, Alaska USA, to get around having to reopen a new account in the name of the trust. Sometimes people have all of their, auto debit, auto transfer, auto pay transactions hooked up to a certain account. If they had to all of a sudden close that account and open a new one, it's an incredible inconvenience. So there are ways around that, but we know all the tips and tricks here to get that stuff where it needs to go, at least at your death. Try to avoid the probate. Oh, I forgot one very important part of my trust bucket. I just saw it. Good thing it's bright yellow. This is not a shovel. This is a pour over will. So what a pour over will does is it's a last will and testament, just like any other will that you would do, except the most important thing it says is everything in my probate estate, i.e. stuff that's not already in the trust, right? I hereby leave to my trust. So it just scoops up all those little oopsie daisies and dumps them right back in the trust, because it is standard Alaskan practice to fly to Hawaii, drink too many Mai Tais, buy a condo in your own name and forget to put it in your living trust. I am not joking. So we always, always, always do a pour over will just in case. Okay, so we have this little slide when you might want to use a living trust. I've alluded to a couple of these things as we've gone through, right? You don't want to deal with probate. You don't like that time delay. It does take somewhere between 2 and 3 months right now between when the probate court receives my documents to actually open a case and for them to actually get it open. One of the probate masters passed away last year, so they're still getting the new one up to speed. There's also the time delay of COVID, and things are like sometimes electronic, but not always. It's just so, yeah, things take time. It is what it is. When you own property in more than one state, right? Snowbirds, talking to you. And when you have a taxable estate, which we'll talk in a little bit about what constitutes a taxable estate. And if you want help with your financial affairs and you want that transition to be more seamless, right? The incapacity piece is huge. For whatever reason, banks seem to be less leery of a successor trustee and that documentation than a standard power of attorney. I don't know if it's because they think, oh, there's a trust, there must be a lawyer involved or what, but with powers of attorney, banks are very, very nervous at all times. They, eventually it does get the job done. It's a legal document, but you have to jump through a little bit more hoops and just wait a little longer for them to kick it up to their legal department. And of course, if you want to leave your inheritance to your spouse or your loved ones in a protective trust, doing a living trust is one way to do that, but you can actually also do that in your will. So when I get to a later slide that says that, just confirm, if your will says, I leave my property to so-and-so in trust or in a special needs trust that's not an includable resource for the purposes of Medicaid, then you can actually create a trust. We call that a testamentary trust because it's created by your last will and testament. It's created at your death. That can be done with just a standard will. You don't have to create a trust. You don't have to do a living trust that's yours, that's funded, in order to create a testamentary trust for your loved ones. And then if you want your affairs to be private and you don't want Joe Schmo off the street looking up your probate case. Okay, so I mentioned putting things in trust for loved ones. And the question is, why would I want to do that? Well, I'm so glad you asked. So standard wills, joint titling, beneficiary designations, all of that is just giving money to people. And then when it gets to them, whatever happens, happens. If they've got big fat creditors, if they're getting divorced, and that money is then subject to the claims of those creditors or subject to the terms of the divorce, it is what it is. You do have the option to create a nice little trust bucket or a trust bubble in my little picture here to protect your beneficiaries from their own creditors. So in creating a testamentary trust, you can do something for your loved ones that you cannot do for yourself, which is transfer this money into a bucket for them. The difference between an inheritance trust and a living trust is this inheritance trust does not have the social security number of your beneficiaries. Your beneficiary's social security number never touched this money. It went straight from you to the inheritance trust. So technically, that beneficiary's creditors had no reason to ever expect that this money would be available to them. So it's not for them. It can still be used to pay for the expenses or pay for things for the beneficiary, but it's not attachable by that beneficiary's creditors. So that's the magic of an inheritance trust. I've definitely had clients say, well, if my kids have creditors, that's their problem. That is true. It's all about your perspective, right? Like, what dragon are you trying to slay? So if you don't want to make things complicated and you're like, I taught my kids to pay their bills and stay out of trouble, it is what it is, also fine. It's your plan. Okay, so yeah, there's some benefits. I'll let you cruise that slide on your own time. Let's jump into the estate tax. Oh, it's so fun. Okay, so the estate tax got a little bit of play at the beginning of this year in January. That's when they always talk about changing the estate tax. And in the end, no changes happened. All things are exactly the same as they were, which is, the status quo for politics. Talk a lot about something, scare everyone, and then nothing happens. Right now, the estate tax is still an excise tax, which means the estate pays the money off the top, and then the beneficiaries get their share. This is different than an inheritance tax. An inheritance tax is a tax on somebody that receives an inheritance. Those are imposed at the state level. Some states have them, some states don't. Alaska does not. We hate inheritance taxes. We don't love estate taxes. We don't have either of those things. But what property is subject to the estate tax? Well, anything that's in your name plus half the property that's jointly titled, and anything you can name a beneficiary on. But you have the unlimited marital deduction. So if you have a United States citizen spouse, you can leave them all your money and they don't pay a single dime of estate tax. However, when they die, it's time to pay the piper, right? So Bill Gates leaves everything to Melinda Gates when he dies. Melinda pays 0 estate tax. Then Melinda dies. She gets to use the coupon amount. We won't get into the nitty gritty, but essentially you can say, okay, right now we all have our one coupon. A spouse can use their deceased spouse's coupon if it wasn't used up because they left everything to their spouse, plus their own coupon. So when I'm doing the math on whether you have a quote taxable estate, I'm adding 2 exemptions together, one for each spouse. And then I think that's kind of the threshold for whether you're going to have an estate tax problem. What is the estate tax, you ask? Well, it's currently $12.06 million, but in 2026, the current law is subject to a sunset provision. It's going to drop back down to $5 million indexed to inflation. They're projecting that that's going to be like $6.5, $7 million. I don't know. Apparently inflation is really crazy right now, so who knows? But it's $5 million indexed to inflation, which is very different than 12.06. And again, this is per person. So somebody dies this year, $12.06 million estate tax threshold. That means for a married couple, we're looking at 24 and some change, right? That's a lot of money, a lot of room to work with. If you're charitably inclined, the easy answer is everything over the estate tax, just give to charity. But there are also other cool ways to provide for charity we'll talk about in a few minutes. All right, so what else can you give away without having to worry about taxes? Well, we all have this lovely $16,000 annual exclusion, so we can just give away $16,000 to each of our best friends and no one cares. The IRS doesn't require anything be filed by you, the person who gave the money. The IRS doesn't require the person who received it to file anything. It's just manna from heaven. Now, that does mean that husband and wife can really leverage this, or you could leverage it for a child or someone else who's married. So the example is, say your kid wants to buy their first investment property and they need enough money for the down payment. So you give $16,000, your spouse gives $16,000. If your child is married, then you can give $16,000 to their spouse. Your spouse can give $16,000 to their spouse. And now all of a sudden you've gifted $64,000 and no one cares, including the IRS. That's just great. What happens if you gift more than that $16,000 to any one person? Let's say I gift $16,001 to my child. Then I have to file what's called a 709 gift tax return, which is basically a document that says, "Dear IRS, I exceeded my exclusion amount for the year by $1. Please deduct $1 from my overall coupon of $12.06 million. So if the question is, should I not give away money because of gift taxes? The answer is very likely gift tax is not something you actually have to be concerned about, because until you get to that $12.06 million mark, because it is changed to it's the estate and gift tax, they're the same number, then you don't have to worry about a tax. So if you want to see the impact of the gift, well, by golly, make the gift. And to confirm, gifts to charities are not taxable. In fact, they're very often tax deductions. Okay, so yeah, we don't have an estate tax here. We don't really like taxes. It's Alaska. But other states do have them, and very often folks have connections to those other states. The best examples are our People's Republic of Washington and People's Republic of Oregon to the south. Both have state level estate taxes. Oregon's at $1 million. It has been for as long as I can remember. Washington is now, I believe, at 2.193, and it got frozen at that amount because they like eliminated the index that they use to calculate inflation or whatever. So anyway, those states, if you own property in those states, there is an estate tax component to your overall estate plan, because those states capture a pro rata amount of their estate tax based on the property that you own in those states. So just because you're an Alaska resident doesn't mean you're home free if you own property in Washington or Oregon. Okay. So just to summarize, if you're doing a will or you're doing a trust, it's part of a bigger picture, right? We talked about beneficiary forms, but at least in my office, we kind of view things as a package, right? If somebody comes in for their power of attorney, I'm not going to not do a will. If you come in for a will, I'm not going to not do a power of attorney. So we do a will or a trust. And then if you do a trust, that pour over will, right? For the Hawaii condo. And then we also do the power of attorney, healthcare directive, memorial instructions. We'll do personal property memorandum so that all of those, pieces of artwork you've got rattling around, guns, jewelry, furniture, things you want to go to specific people, you can do a list of those. And we'll also give you some advice on the beneficiary designations. In some cases, we'll do them for you, just to make sure that the trust is funded properly. And for proper titling of financial accounts, we will help you work with your advisor if you've got one, or assist you with the paperwork ourselves if the trust is the beneficiary. Same thing for real estate. I will just do a deed. You should never do your own deeds. If you take nothing away from this presentation, it doesn't have to be me, be any, well, I shouldn't say any lawyer. Just make sure a lawyer, somebody with malpractice insurance, does the deed, because I see some pretty horrific mistakes that come in deeds that cause great big headaches after someone dies. And then a community property agreement. We sometimes do LLCs to hold property. Community property, actually, before I get to Harry, I'm going to touch on community property just briefly. It does have a lot of tax benefits for married couples. So if you are one half of a married couple, you may consider doing a community property agreement if you guys are a joint financial enterprise, just because it eliminates the basis. Well, I should say it gives you a step up in basis at the death of the first spouse. So the IRS basically says, I can't tell whose half is whose. You each get a full adjustment in basis no matter which of you dies for property that's scheduled as community property. But you have to opt in if you're an Alaskan couple. That's just a quirk of our state. So now for more fun with charitable planning, the lovely Harry Need.
Thanks, Chelsea. I just wanted to speak on retirement assets because there's such an amazing opportunity to make a charitable gift and simplify your estate planning. I think many of us, along with our house, our retirement assets are going to be some of the largest, most valuable things we own. Whenever you give that to a human being, those humans are going to have to pay tax on the distributions from those retirement funds as if they were in, the income by those humans. For under the Setting Every Community Up for Retirement Enhancement, I think, of 2019 Secure Act, there's a 10-year rule on 401ks and IRAs. It means that you have to actually spend that money out in that 10 years and empty that retirement fund. Now, what this looks like often is somebody who is in their highest earning year of maybe their whole life, their mid 50s, early 60s, inherits a retirement fund. And now they're paying the most amount of taxes they could ever pay because they're also at the peak of their career. Alternatively, we see this coming to 20-year-olds who have no business managing a $500,000 retirement fund or more. And so it creates a problem. This is a planning problem that can be overcome with planning, and particularly by naming your favorite charity as a whole or partial successor beneficiary on your income, or excuse me, on your retirement plans form. Charities do not pay income tax. And so you can have those assets transferred to charity just by a matter of calling up your fund administrator and asking to modify your beneficiary designation. Chances are, if you're working with an attorney to get your estate plan in order, you're working through all of your beneficiary designations already because they're prompting you to do that. But this is a great planning tool and a great opportunity for charities, particularly if you are over 70 and a half. There's an opportunity to have your required minimum distributions transferred to charity directly, avoiding income tax altogether. That's called a qualified charitable distribution. And while not necessarily a planning tool, it's definitely something Elizabeth and I would be happy to talk with you about anytime. And particularly as you're thinking about these gifts, planning with the charities and working to create a strategy with those assets that achieve your goals with the charities. And with that, I'll hand it over to Elizabeth to talk a little bit about donor advised funds.
And I am here, and I was waiting for my picture to appear on the screen, but it's okay. So donor advised funds are a tool that donors use either with current assets or with testamentary assets. And you can set up a donor advised fund at ACF or some other nonprofits or organizations like Fidelity, Schwab, Vanguard, et cetera, have the donor advised fund option as well. And basically with current assets, you get the immediate tax benefit when you contribute to your donor advised fund, and you can grant out those funds from your DAF, as we call it, a donor advised fund, DAF, anytime in the future. And so it's a great way for you to consider doing current charitable giving. And when you're looking at planning your legacy, it's a wonderful way to involve your family members, because your family members can be the fund advisors after your death, if that is your wish. So it's a great option for current giving and a wonderful option for testamentary giving, if it is your wish to set up something like a very simple family foundation. With that, I'll turn it back to Chelsea.
Zoom. I'm going to bounce it back to Harry because I know that he has experience with these many different types of charitable plans too.
Yeah, I think that we're getting into the alphabet soup version of planning. Between IRAs and QCDs and DAFs. Now we're talking about CRTs and CRUTs and CRATs and CLATs and CGAs. Bottom line here is that there is probably a tool somewhere in the Swiss Army knife that's appropriate for you. Appropriate for your planning. We work with a lot of donors on creating trusts that at the end of doing the thing that they wanted the trust to do, the rest goes to charity. There's different ways to structure that, including the charitable lead trusts, where instead of having the rest go to charity, the rest could go to heirs, and you could have payments structured to your charities over those first several years. Charitable gift annuities we write at the University of Alaska Foundation are simple contracts between the donor and the charity. I think many of you probably have seen advertisements for these over the years, but it's a simple contract where an asset is transferred to the charity, and in exchange for that asset, the charity makes lifetime payments or payments over a number of years to one or two beneficiaries of the CGA. And then again, that money's invested and the rest goes to charity. The endowment model is attractive for a lot of people because the idea is that the principal can be transferred to the charity. The charity can invest that over time, as the University of Alaska Foundation does with approximately $500 million of endowment dollars. And the earnings from that can then be transferred to create impact in the community forever. Typically, those are indexed to beat inflation over time. So the amount of impact you are seeking remains the same, inflation adjusted, for hundreds of years. The private foundations is a bit of a departure, but what we're looking at here is the creation of your own entity for charitable purposes. That's something that Chelsea could definitely work with you on if you were so inclined. And we've talked a little bit about lifetime gifting already, but the idea of to the extent that you can get money out of your estate while you're still alive, just how much more fun is that than having some balance transfer happen when you don't even know about it. So that's just some other thoughts related to how your charitable strategies can be deployed while you're still alive. And I think at this point, what I'd like to do is introduce another guest speaker. Heather's been very patient to stay with us online, but we're kind of approaching the end of this presentation. And I thought it would be really nice to hear from somebody who's sort of been there, done that. Heather, many of you probably know at least as well, if not better than I do, but she began her career as a teacher and taught at all levels from pre-K to graduate school. In fact, she's teaching with the OLE program this evening at UAA. She now retired. She led the Adult Learning Center for UAA. She served as the executive director for AWAKE and the Alaska Women's Resource Center. In 1975, she was elected to the school board. Then she served on the assembly for 10 years, 5 of which she was the only woman, and she was known for her expertise in budget, finance, planning, zoning, and utilities. She continues to be active and engaged with community serving many organizations such as the YWCA, the Opera, the Alaska Community Foundation. And she was recognized for all of this service by numerous organizations, including UAA, which conferred an honorary doctorate of humane letters to Dr. Flynn just about a year ago. So along the way, she's also become a generous philanthropist, committing half of her income to charities across Alaska. And she's been in your shoes. She's considered how her plans will reflect her values. So we thought it might be useful to hear from her as someone who has been there, done that. With that, Dr. Flynn, the floor is yours. And the question I have for you is, how did you approach your planning?
Wow. Dr. Flynn, nobody's called me that. Here's my red book. Susan Foley did the first one, actually the first of this one, then Richard. And Chelsea, I think you recently completed some stuff for my daughter and she speaks very highly of you, so good work. I've been involved with the Anchorage Community, what was then the Anchorage Community Foundation from its very inception, and now the Alaska Community Foundation. And I give because I can. I've been a very prudent investor all these many, many years, and I have enough assets and I don't need them all, and I live pretty frugally. I also have 2 wonderful children who are remarkably well educated, very well employed, do very well for themselves. I love them dearly, but I've never met a trust fund kid in my life that I thought was worth a damn. So while they have enough to settle my estate, the rest of it is going to charity. Now, what do you do? It's just what Elizabeth said earlier. What do you love? What's important to you? And so I fund not only now, but when I die. And by the way, I will say to all of you on there, if you have resources now, give while you live. You know where it goes. I tend to give almost exclusively locally, not nationally or internationally, although I've funded a few things. But for the most part, what I give is right here in beautiful downtown Anchorage and a few of them around the state. What do I love? I love education. I love music. I've been very deeply involved in issues surrounding women and children. And I also really love public radio. So therefore, that's where my money goes now. Not only, I haven't finished my taxes yet, But as soon as I do, my RMD, and by the way, those of you out there, RMD is a great way. You don't have to take it as income. You make direct, and boy, those checks just roll out. It's very, very easy. And my broker makes it very easy to do. And I recommend that you all try using that wonderful method. Now, one other thing that I guess I'd like to impart to each of you is I have a relatively simple will. And I will give Richard a lot of credit for this, because I didn't want to give percentage of this or a little bit of that or blah, 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 blah. What I basically did was do all of the basics, all the legal things. And then I said, see attachment A. Attachment A is the contract that I have with the community foundation that says my money goes, 20% here and 20% there and da, 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 da. And what's really great about that is it's completely revocable. So if I get really pissed off at some organization and I don't think they deserve my money any longer, I go in and I revise attachment A. And as a matter of fact, I have an appointment with Elizabeth on Friday because I am going to do some revisions. Not so much because I'm annoyed at an organization, but I do look at the whole issue of successor organizations. And the other thing is, now that my children are well into adulthood, and I love them dearly, and they have finally also made their estate plans. I swear I had to pay my son to do so. But now that they have, and I deeply trust their judgment, we're going to form a family legacy or something. We'll call it whatever we do. And so whatever's left, they get to make the decisions, which may be appropriate at the time, but may not be appropriate today. So I'm moving forward with the family legacy, or whatever it is we're going to call it. And I'm not subject to estate taxes. I don't have that much, but I have my fair share, and I want it to go where I live, where I have benefit, where I have grown personally, where my children have grown and been educated. And it's important to me to be able to give back to the community that has given so much to me. That's it.
Thank you so much, Heather. I mean, it's powerful, right? Like being able to do this kind of thing while you're alive and well, and making that impact on your community, and knowing that your kids get to carry the torch. We definitely have a lot of families that get their kids involved in charitable giving from a very young age and kind of instill the importance of that. So I'm going to go ahead and share my screen back one more time. Just to give you guys the little prompt that says we're going to give you an evaluation form. And actually, I think this is the time that we've allotted for Q&A. So Harry or Elizabeth, if you want to throw that link to the evaluation form. I know that a lot of you registered through one of those organizations, so I'm sure they'll send it out after the fact. But if you want to throw that in the chat or the Q&A, then everybody can access that. It's just going to collect some information about what you thought was great about the presentation, what you think we can improve. And if you want follow-up from somebody at my firm, we're happy to follow up with you and just answer questions. We love the Community Foundation. We love our university system. So we're happy to kind of provide that support. Okay, so it looks like we have had some upvoting just a little bit, and we've got some questions already in the queue. So where should these completed forms be kept? Oh, such a good question. So once upon a time, Susan will laugh, we used to instruct people to keep them in the freezer a long time ago, because in the event of a house fire, the freezer is the most insulated part of your home and nothing will survive a fire except for a freezer. The problem is we had a total of 0 clients in the firm history ever lose their documents in a house fire. not one. But people misplace their documents all the time because they put them in very strange places, like, I don't know, the freezer, not to mention the unique problems that come with a freezer in Alaska, like moose blood, berry juice, fish guts, right? Like freezer, not a safe place for your will. My general recommendation is if you feel more comfortable putting it in a safe, like a gun safe or a fireproof safe in your home, great, fine, no problem. Just make sure that your agent, whoever's named in those documents, one, knows where it's at, and two, has the key or combination, right? Because it's all well and good if they know where it is, but if they can't get to it, doesn't do anybody any good. I will also say my hard line on where not to put it: do not put your documents in a safe deposit box. Even if you have other signers on that account, it could just be incredibly problematic. Like people show up at the bank and they say, oh, my mom's will, it's in the safe deposit box. And the bank is like, prove it. And they're like, well, open the box and then you'll see it. And they're like, we can't open the box, prove the will is in there. Like, it's just, anyway. So if you don't feel like you need to have it locked, I have a lot of clients who don't. They just pop their red book just right up on the shelf above their computer in their home office. Chances are, if somebody's breaking into your home, they're looking for like prescription drugs, cash, guns, right? They're not probably looking for your red book. So that's fine too. Okay, and then here's the next question. In Alaska, after age 65, you get an allowance for the value of your home for your property tax. I think you're talking about the senior citizen tax exemption. If the house is in a trust, like a family trust, you can't claim the exemption. Is there a way around this? Okay, so if your house is in your own living trust, of which you are the grantor, you still qualify for your residential and your senior citizen tax exemptions. You have to provide certain pages of the trust to the municipality or to the borough to maintain that exemption. So they just make you jump through a couple extra hoops, but you do still qualify. If the term family trust kind of throws me off there, because if somebody has like an inheritance trust, right? I talked about those sub-trust buckets where the property is in the social security number different from the beneficiary, then that might cause some other problems. But if we're talking about your own house in your living trust, you 100% still get your residential and senior citizen tax exemption.
Chelsea,
Okay.
there's one question with 3 votes. I wanted you to address that first. If you want to set up a meeting with an estate planning attorney, what documentation do you bring to that meeting?
Oh, thank you. Sorry, I just reordered my votes from most recent to most upvoted. Oh, attorneys and technology, even the young ones. Okay, so we actually have a very long form that we ask you to fill out before you ever come into the office. And we have a lot of documents we ask you to compile before that first appointment and actually provide to us either electronically or by dropping them off at the office. You can mail them if you trust USPS after COVID, great. But it's things like bank account statements, retirement account statements, life insurance policies, deeds for your house. If you have any annuities, investment accounts, basically every single thing in your estate with a dollar sign. Anything that's worth something, I want to know. I want to know about your cryptocurrency. I want to know about that weird cabin in Virginia that you're a quarter owner in with your siblings. Like, I want all of it because it really helps us hone in on where the issues are in titling and whether there's something that we need to fix. And just by actually helping clients find the motivation to gather all this paperwork, we catch a lot of really weird issues. I had a client not too long ago whose the deed was just recorded, or I guess it was misfiled by the recorder's office. And so the muni never knew that the property got sold. And so although she had bought an apartment complex, she was not reflected as the owner. And so we had to go do some digging and work with the Department of Natural Resources and the muni to get that cleaned up. So it's amazing what you discover when you force everybody to go through their paperwork. But essentially all the things, at least if you're going to work with our office, we do really make you do your homework. But it's good. It's like eating your spinach, as Richard used to say. Okay, so I also see a question here. If you want to set up a meeting with an estate planning attorney, oh, sorry, that one. Did I miss there? Was there another one that I skipped over then, Elizabeth?
No, I think the next one is, what can I expect to spend to have a living trust and will drawn up?
Great. Yes, I see that one too. So the question is, what is the kind of cost you can expect for a living trust? And that really depends based on what kind of trust you're doing. I can certainly give you a ballpark range for what our firm charges, but we do our planning on a flat fee basis. Some firms, the thing that everyone hates about lawyers, charge hourly. And my understanding from the founders of the firm is that this type of planning really benefits from a flat fee because the client knows what to expect. Everybody knows what to expect. The problem is you're not going to, if I'm charging you by the hour, pick up the phone and call me and ask me all your burning questions or make those changes you need to make because you're worried about me running the clock on you. So at least for a living trust based plan, if you're just looking for a very streamlined probate avoidance trust for say a couple, you're typically looking in the $7,000 to $8,000 range. If you are doing more complicated planning with a level of estate tax planning, then you're somewhere in the neighborhood of 8 to 10, depending on how complex it is. And if you do have a taxable estate and we're trying to do tax planning, then we're looking at over the $10,000 mark. And it really depends on the clients, because sometimes we're working in LLCs to hold rental properties or working with, complicated business documents to transfer assets to the trust. It just really depends, but that's kind of the ballpark range. And you'll notice that's a big swing from like the will price range, because for a couple to do a basic will-based plan, you're looking probably more like $3,000. And that's, will, power of attorney, healthcare directive, HIPAA release, like just one little neat tidy package for both spouses is $3,000. The difference in price comes from, at least for us, this part of getting the stuff in the bucket. We focus really strongly on fully funded trusts because very early on in the firm's history, when the trust would get drafted and the client would get a letter that says, okay, now here's how you get all of your assets from here to here. How many clients do you think successfully completed that action of getting all the assets into the trust? Right? Not a one. So we've found that when we do that part of the work, it really makes everything work a lot better, because otherwise what happens is you draft this big fancy trust, then you send the client a letter, they never do it, they die, their family comes in furious that they had this fancy trust and why isn't it working and why do we still have to go to probate? And you're like, well, here's the letter I sent your mom, sorry. So we now focus on funding our trusts. Some clients prefer to do it themselves, which is okay. And I just write them giant CYA letters about that. Okay, so next question, revocable or irrevocable trust? Living trust with lots of question marks. Good, okay, yes, to clear this up. A living trust is in your social security number and it is during your lifetime. That's what makes it living, and it's revocable. So that means you can change it, you can revoke it, you can get rid of it, or just modify it. You can do what we call restate it, just completely change the terms. Like the only thing that stays the same is the name, right? The name would be the same, but everything inside a binder changes. That's a living trust. Now, what happens when somebody leaves assets to another person in a trust? That trust is irrevocable. The person who receives that money has no control over the terms of the trust. They can't change it. It's irrevocable from the start. There are types of trusts that are irrevocable that individuals can do for themselves, but that's really outside the scope of this workshop. They're called domestic asset protection trusts. They're completely different animals. And there are some other estate tax planning tools, again, outside the scope. So for our purposes, the main difference you want to keep in mind is the living trust that you do for yourself, and then the sub-trust it can create for your beneficiaries, if that's the way you want to do it. Those are irrevocable. Your beneficiaries cannot change the terms of those trusts. Okay, so what are the top 2 to 3 things someone should start with to get the ball rolling on planning, especially if you're brand new to this? I would say if you're married, have a conversation with your spouse. If you're not married, but you have a partner, have a conversation with them. Or if there are other important people in your life that might be serving as agents, have a conversation with them. Met with a number of clients where we get in here and we're signing the documents and they say, honey, we probably should tell them we named them here. Yes, you should. It's rude not to. But just talking with the people in your life that make a difference. If you are interested in plan giving, talk to the charity, see if they have, certain needs or what their giving options are, and just kind of get those wheels turning. If you want to work with us, I always say, oh, the first step is going to a webinar. Check. And then every firm will be different in kind of how you engage them to do the work for you. For us, we send you a personal information form that you fill out with all the names of your kids or your other beneficiaries, birth dates, phone numbers, all the basic information. And we also request all that asset information up front, right? Like I want all of those statements that we discussed earlier. So kind of forcing yourself to go through the exercise of gathering all your asset information, no matter what attorney you wind up working with, I think will be helpful. It's a useful exercise. Even if you're not going to work with a firm like ours who makes you do it, it's just good to know who your beneficiaries are because they might not be who you think. Okay. And then I think we answered that. Okay, does a trust avoid estate tax? Boy, that's a very broad question. So depending on how a trust is drafted, it can mitigate some of the estate taxes. There are things we can do for married couples, especially that allow them to shield wealth for the successor spouse and basically leverage the estate tax exemption so that the survivor can pass more exemption on to heirs that aren't covered by that unlimited marital deduction. But at some point, if you have gobs of money, the only way to truly get rid of taxes is to leave a portion to charity. So that's why the Bill and Melinda Gates Foundation exists, right? Because at some point you have so much money that you can't estate plan your way around it. And you either have to give it to the government or to a cause that you appreciate. So hopefully that's enough of an answer for that one. How are bank accounts with a POD, short for pay on death designation, handled at the death of the account holder? Good question. It's actually very straightforward. Whoever is the beneficiary, or perhaps the personal representative, if the beneficiary doesn't know that they're listed on that, would waltz into the bank with a death certificate and the bank then processes it. Like there's no other paperwork involved. If you have something like life insurance, there's a claim form, right? Or a retirement account, same kind of thing. But for a bank account, it's just a death certificate and then the internal paperwork of the bank itself. Super straightforward, very fast. So the only thing that really causes any delay is getting the death certificate. All right, now when transferring real estate to a living trust, must one obtain a mortgagee consent and or change the name of the borrower on the mortgage? No. You can just move it to the living trust. It's fine. It's not the same for LLCs. That's a different animal. But you are allowed to transfer your primary residence to your living trust without triggering the due on sale clause for your mortgage. Okay. And do I do a consultation without launching a estate planning process? It depends. The good problem we have is, for better or for worse, we are very busy right now. We're very busy. And so if it's a consultation about, say, a postmortem administration, especially something that might have litigation involved, I usually refer that out. If it's an estate planning consultation, then I'm happy to have a quick chat on the phone before you even decide whether you want to move forward, because we are screening our potential clients as much as they're screening us, right? We want to make sure we're the good fit. It's like a doctor, right? You want them to have good bedside manner. You want to have somebody that you feel comfortable working with. If you dread going to see them, like how effective is that plan really going to be? So hourly consultations, we do them on occasion, but we screen pretty carefully first. So if you're interested in some sort of consultation, you can call the office. They'll put a message in. It definitely takes me at least 5 to 7 business days to get back to people. And keep in mind, I'm hopping on a plane, so add a week to that. Okay, next question. If retirement assets are left to a trust, does the trust pay the tax on that income? That's such a good question. Sometimes, yes. It depends on the type of trust. Trusts can have, oh, sorry, one second. As an Alaskan, I hate to block out the sun. That needs must. So if the trust does not have what we call look-through provisions, then it can wind up paying that tax at the trust's income tax rate. Additionally, even if we do our darndest to draft the trust in a way that includes those required provisions by the IRS that allow the custodian of the money to look through the trust to the life expectancy of the oldest beneficiary, in my experience, the retirement custodians can just be ornery. I mean, they're just like, nope, we won't do it. We'll have nothing to do with it. 5 years or lump sum, your option. In which case you can either just drink the Kool-Aid and take your 5-year payout, or just take it as a lump sum and eat the tax. Or what we've done in the past is actually transfer it to a friendlier custodian, because some custodians are more willing to play by those rules than others. It just depends. So we'll do a custodian transfer of the funds, move the whole IRA, then distribute it out, knowing that that one's going to play ball. So that's kind of how we deal with that. And is there any problem with irrevocable Alaska trusts when a person dies as compared to a standard trust? I think maybe you're getting at the domestic asset protection trust. If it's a self-settled form of trust, they're not really usually a problem when people die. They're more of a problem while people are alive. Because what happens is if somebody creates an irrevocable trust for themselves, then they find that they later want to change things, but because it's irrevocable, they cannot. So you have to kind of cede control of your money. You just give it over to somebody else and say, can I have some money? And maybe they say yes, and maybe they say no. And you're like, it's my money. And they're like, not anymore. So that's self-settled trusts. For irrevocable trusts that are created by somebody else in the context of an estate plan, those in my experience are typically pretty easy to work with. For the beneficiaries, depending on what bank they bank with, some banks get more confused by them than others. I won't name any names here. That's not polite. But the banks that understand them do fine. It's just a certification of trust. It's like a little 2-page form that says, I have a trust, I'm the trustee, this is the tax ID number for my trust, and I'm putting this money in the trust. And then there's a bank account in the name of the trust, and they're able to manage that money just as a living trust trustee can manage their own. Okay, and last question. Oh, goody. Unless somebody has other questions, now's the time. Many people have extensive art collections. Yes, true. How do you recommend dealing with their artwork in their estate plans? It's a really specific question. It really depends on what the goals of the client are. If it's highly appreciated and it has some historical value and you're charitably inclined, perhaps leaving some of that appreciated artwork to the charity specifically is an option. Your beneficiary or trustee, I should say, is going to have to likely get that appraised at your date of death. And as far as I know, there's like one true art appraiser in this town. Her name is Melissa Faust. I'm terrified she's going to retire. But that can be not problematic, but just a big piece of the estate administration is like getting all of those appraisals, which is not cheap. I mean, Melissa charges the same rates that some attorneys do, and she's worth it. But that's what can happen with that kind of artwork. Now, if you say extensive collection and we're not talking about value, we're just talking about volume, then that can often be auctioned off. If you have specific pieces of art that are, not worth an exorbitant amount, that are less than 10 or 15 grand a piece, you can always put those on a personal property memorandum, which, just like when Heather was talking about being able to update, I think she called it Schedule A, whatever Richard called that, donor advised fund agreement. They referenced it as Schedule A. You can update your personal property memorandum, and you don't need an attorney to do that, which is why I generally suggest to clients that for those kinds of things, they list it on that form and keep me out of it. Because if you put every single painting in your living trust, then guess who you have to pay when you change your mind, right? Not the end goal. I don't have time for that. I don't want you to spend your money that way. I just give you a form and you write who you want to receive those items. And then as you get rid of them or change your mind, you update it yourself, and I don't have to worry about it, and you don't have to pay me. It's great. And I have no open questions. So I think everybody fully understands estate planning and is ready to take the leap and at least do their powers of attorney, healthcare directives, and check their beneficiary forms.
Yes, and Chelsea, thank you again for presenting. Somebody had asked, and I typed the answer. I just want to say we will be sharing the slide deck. Chelsea has generously allowed us to share the slide deck, as well as the session was recorded, and we will be sending a link to the recorded session as well. So every attendee will be getting that information. Thank you all so very much.
Yes, thanks to everybody who attended. It's always great to see a turnout like this, especially on a weeknight. I know it's hard to make the time, but thank you all for making the time. A special thank you to Heather, Harry, and Elizabeth for putting this all together and being willing to chip in. This was a group effort for sure.
Thank you, Chelsea. We really appreciate it.